Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. We have a matter at 1 o'clock today, which is Marbella Lakes versus Elkins, an evidentiary hearing set to take the afternoon. Sorry, I'm about 2 minutes late. We had a judges meeting over the lunch break, and I transitioned as quickly as I could to open this meeting. All right, we did have the beginnings of a hearing, so I'm a little bit familiar with regard to the plaintiff's motion here. I believe the motion's been amended slightly, seeking a temporary injunction with regard to Ms. Elkins. Mr. Gal, you're appearing on behalf of the plaintiff at this time?
I am, yes.
All right, and Ms. Elkins, good afternoon to you.
Good afternoon.
Are you still representing yourself at this time, Ms. Elkins?
I am, Your Honor.
Okay, very well. All right, then what we'll do, I'm going to invite Mr. Gal to proceed. He has the burden of proving the allegations in his motion in order to try to obtain the relief that he seeks. We've got, I think, a number, at least last time we had a number of witnesses, far too many for the time that we had. So we'll invite Mr. Gal to present witnesses. After each witness, Ms. Elkins, I'll ask if you wish to ask any questions in what's called cross-examination, and we'll proceed accordingly. Once Mr. Gal has presented what he wishes to present in support of the motion, then Ms. Elkins, I would turn to you to hear any evidence or testimony that you want to present on your own behalf with regard to the motion. So that's our overview as to how we'll proceed. And with that, Mr. Gal, I'll invite you to go ahead and proceed.
Your Honor, before we proceed, I would like, for whatever it's worth, I'm not an attorney, but for whatever it's worth, I would like to put my objections on the record. Marbella Lakes is past due on returning request for production and past due on the third set of interrogatories. Due to the delay in returning those documents and evidence to me, I am unable to be prepared for today's motion.
Okay. All right, Mr. Gal, can you speak to that?
Well, we filed a response to her second request for production and provided documents to her. She states that there are other documents that we have that have not been provided to her. This happened over the weekend. I mean, I will go back and look to see if there is stuff that is due her. And we have a response to her third set of interrogatories that I'm going to file tomorrow morning. I just got them. But this is not a final hearing. And the documents she's requested had to do with damages. And for example, we had tried to schedule her deposition and she didn't appear. So discovery is ongoing, but the purpose for this motion is to just request that the court direct her not to engage with some of the homeowners in the association until we are complete and ready for a final hearing.
Ms. Elkins, can you give me an example of something specific that you believe is outstanding in the discovery that would directly affect your ability to address today's motion?
For example, Marbella Lakes is alleging that I have damaged property. They have yet to supply any evidence of said damages. Even though that was requested in the first set of requests for production, that has never been turned over to me, that was requested in the last one that was past due and still has not been returned to me.
Okay.
I mean, I have no idea how to even speak on damages. And while we may not be addressing damages today, we are addressing decorum, conduct, and safety, which they are alleging I violated. If they have violated it by filing a frivolous lawsuit, which I believe may be the case, at least in the sense that I've yet to receive damages, I've yet to receive any evidence from a landscaper, anything that repairs and or replacements had to be conducted on Marbella Lakes. It goes back to credibility here. And yes, they have witnesses, but if they are providing false information, it's going to be he said, she said. The crux of this is what is in the lawsuit and can they support it?
Okay. Well, I think that answers my question, and it sounds like we can proceed today with the following caveat. If Ms. Elkins, if Mr. Gal begins to inquire about something that you believe is the sort of thing where there's a document or they start to allege some sort of damages that haven't been disclosed to you, then I think re-raise your objection at that time specific to that issue, and I can determine whether they should be prohibited from going down that road because there's something that they have not yet shared with you that you have appropriately requested. But I think that for the most part, it sounds like we should be able to proceed. So just object specifically if they start to, the term that sometimes gets used is sandbagging. If there's something where you believe they're sneaking up on you, they should have turned something over to you and now they're trying to use it against you, that's grounds for an objection. So raise it as we go if that comes up, okay?
If I may, Your Honor, getting back to their specific complaint or motion, whatever the right word is.
Well, there's an important difference there. Are you directing your question to their complaint or to the motion?
I am referring to the amended motion for temporary injunction.
Okay, that is before the court.
Number 3, specifically Victoria Elkins has on numerous occasions drove around speed bumps, over speed bump markers, onto the grass on Marbella Lakes neighborhood development. Driveways. There's been no evidence that if this is something that I have requested, that I have driven on driveways, that I have ventured foot or vehicle wise onto someone else's driveway. That is something that I have requested in the request for production that again, it was past due and that I have not received. I'm not sure that makes sense as a request for production. What have you requested they produce? Any evidence, documentation, video, that I have gone onto someone's driveway.
Well, there might not be anything other than Mrs. Jones comes out and testifies and says, you drove on my driveway on December 2nd. I mean, there wouldn't be anything that you'd put in a request for production if that's the case. Now, there might be other ways to find out about Mrs. Jones, but these are very specific and very technical things, and I'm trying to figure out, it's my obligation to make sure both sides' rights are protected here, but if there's outstanding discovery that is going to actually create an unfair advantage today, that's one thing. But if it's just, well, we've got witnesses, but we're not, if you've asked them to disclose their witnesses, that's different. That would be interrogatories. So this is all the sort of thing that an attorney could be helping you with. You're doing a perfectly good job. You appear to be very, very well versed for a non-lawyer, but I do have to treat both sides exactly the same under the rules here. What you've described wouldn't be something that I would think would be produced via production. Okay. And it doesn't tend to be documented. That's a classic example. What would be a documentary piece of evidence? Did you or did you not go in someone's driveway? I wouldn't expect that to be documentary evidence. So I'm going to go ahead and proceed. There may be individual objections that get raised based on certain points of evidence or testimony, but I think we need to go ahead and get started and let's get an idea of what we're talking about here. Mr. Gal, go ahead.
Your Honor, I guess one more procedural type issue. When we left off at the last hearing, I believe we were in Ms. Elkins' cross-examination of Ms. Spinelli, who is the president of the association.
Okay.
Should we start? I didn't have any other questions for Ms. Spinelli. Should we start with cross-examination of her? Or if not, I'm ready to move on to my next witness.
Well, The motion's been amended, so I'm going to ask you actually to recall that witness. You may be a bit more brief. Once she gives a few answers, I think I'm going to remember what she said. But I think specifically we do need to represent, and then Ms. Elkins can cross if she wishes to cross. I remember the very, very basics, but let's go ahead since it's an amended motion and get that done.
Okay, I'm going to have Ms. Benelli sit. No, I guess.
Your Honor, if I may, before we begin, can we have Ms. Benelli remove the mask?
Why?
So we may see her verbal and her physical responses.
Well, do you all have the ability? I thought Mr. Gall had suggested last time that you let everybody stay home, call in on their own devices so they don't have to wear a mask. So I don't have to deal with the fact that now you're 8 feet away from the microphone and I might not hear you as well as I hear your witness. Do we have the ability for everybody to be on their own device, or do we have to put everybody in the room together?
No, the other witnesses are on their own device.
Okay.
I just have Ms. Benelli here.
All right. Okay. Well, I agree that it is ideal for everybody to be able to see each other's expressions. Dr. Fauci would be fairly horrified at what you're doing right now, but you know, however you all want to present your case, I'll let you go ahead and proceed. Let me do this. I've got the witness. Ma'am, would you raise your right hand and I'll get you sworn in again? Do you solemnly swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Would you tell me your name again?
Maria Bonelli.
How do you spell your last name?
Bonelli.
Okay. Mr. Gall, if you want to just go through just some questions to bring me back up to speed as to what you covered last time.
Sure. Ms. Benelli, what's your position in the association?
I'm the president of the HOA.
And how long have you been the president?
2 years.
Are you familiar with the declaration for Mobile Lakes Owners Association?
Yes, I am.
I'm sorry, Your Honor, may I interrupt? I'm having a hard time hearing Mr. Gall.
I'll try to speak up. Ms. Benelli, are you familiar with the declaration of restrictive covenants for Marbella Lakes Owners Association?
Yes, I am.
Okay. I have in front of you, which was provided to the court for the last hearing, something marked Plaintiff's Exhibit 1. Can you identify what that document is?
Yes, it's the general use of common areas and recreational areas.
And can you explain what this document is?
Well, it's part of our bylaws.
Is it the initial rules and regulations?
It's the initial rules and regulations of Marbella Lakes that is presented to new owners.
And so I move that this exhibit be entered into evidence.
All right. Ms. Elkins, any objection with the one-page exhibit on the rules being accepted into evidence?
No, Your Honor.
Okay. Exhibit 1 will be received without objection. You may proceed.
Can you please read paragraph 1A in evidence?
With respect to the use of common areas, including the recreation tract, an owner shall be held responsible for his or her actions and the actions and conduct of such owners' family members, guests, invitees, and tenants. Decorum, good conduct, and safety shall be observed and shall be strictly enforced.
Your Honor, I'm sorry, I have to object. I cannot see the witness due to her not having her own screen. I mean, this is unfair. I'm missing out the opportunity to see her body language.
Okay. I'm going to overrule the objection. At this point, there's nothing that really gets to that issue. At the moment, I don't think it's anything that would benefit the court one way or the other. So the objection at this point will be overruled. You may proceed, Mr. Gall.
As the president of the association, have you received complaints about Ms. Elkins?
Yes, I have.
And about how many complaints have you received?
Do you know how many receipts? I would say over 100.
Okay. And generally, what are those complaints about?
Her driving excessive force excessively down the streets, horn honking, rolling down her window and intimidating people, screaming at them, cursing at them, driving when she sees kids, driving towards the kids and going around the other way, intimidating people, coming to our board meetings and screaming and yelling and interrupting our meetings that we had to hire a security officer to come into our meetings so she wouldn't disrupt our meetings.
So let me, has Ms. Elkins disrupted a meeting while you were there present as
Yes,
the president?
absolutely.
Well, what happened?
She'll walk into a meeting, or the first meeting we had outside because of the pandemic and our clubhouse was closed. She came in screaming and yelling, freedom of speech, and she's going to sue all of us, and she can buy and sell all of us, and she's just going on, and people are asking her to be quiet, and she wouldn't, and she just screams over everybody. Then finally, I just had to adjourn the meeting, and everybody had to go home. And she went after one of the residents that I was trying to get him away from her because I didn't want any physical altercations with her. And when I turned him around, she spit on him.
Has this happened at any other meetings besides that?
Yes, at least 3 or 4 of our other board meetings, she'd walk in and come to the room, front of the room, and start screaming and yelling, freedom of speech. I have every right to speak, and we're trying to tell her that yes, she does, but she has to do it in the correct format. We were going to let her speak, but she just screamed and yelled over everybody, and we just couldn't, get her to realize that this is not the way you conduct yourself at a meeting, but it was useless. So again, I had to adjourn the meeting, and we didn't finish our business.
Have you hired security as a result of Ms. Elkins?
Yes, for the last 3 board meetings that we've had, I had to hire a Collier County Sheriff to come in and sit at the meeting. And apparently, this is just my opinion, but she probably sees the sheriff's car in the parking lot and she doesn't come in. That's just my opinion.
After our last hearing with Ms. Elkins, did she approach you?
Yes, she did. I was sitting in my neighbor's driveway because they were staying with my husband because he was getting over an injury. And she comes walking by and sees me out there and comes straight across the street and stands in front and starts, in all honesty, Your Honor, I just turned her off because she upsets me. And then all of a sudden now she's concerned about my husband's health after she's prohibited him from walking with his walker to get back home.
How does Ms. Elkins prohibit him from walking?
She stood right in the middle of the walkway and she would not let us pass. So I tried to go around her, and she accused me of hitting her with my husband's walker. And I'm going to call the police because I said, yeah, call the police.
This was an earlier time?
What do you mean by earlier time?
Prior to her speaking to you after the last hearing?
Yes. And the cops came and she gave our statements, and she gave them a video of the incident.
I have no other questions, Your Honor.
Okay. Ms. Elkins, any cross-examination, any questions that you want to ask of Ms. Bonelli?
Yes, Your Honor. Ms. Bonelli, you mentioned that there's been over 100 complaints.
Yes.
How were they conveyed to you?
They were sent through emails.
So you have over 100 emails of complaints?
Approximately, yes.
Was that something that I requested in the request for production?
And I believe you got them.
Over 100?
Well, I know we gave your previous lawyer a lot of documentation, so
Let me jump in because I don't want to get into an argument. Ms. Bonelli, you're under oath. Did you turn over all of the email complaints that you have received?
Yes, ma'am.
Okay, go ahead, Ms. Elkins.
Your Honor, they are not over 100 as she's alleging.
Okay.
Ms. Bonelli, who are these complaints?
Residents from the community.
Are they available to testify today?
No. We didn't
Why
ask.
why are they not available to testify?
Objection. Ms. Elkins can subpoena those you would like to.
Sustained. Ms. Elkins, if those emails have been turned over to you, you can subpoena any author of any email if you want them to testify. This really isn't the ultimate trial, though. This is just whether there should be a temporary restraining order. But the question isn't really a proper one. Go ahead, ask another question.
All right, so what happened at the first meeting? At the first board meeting that you allege I interrupted?
Well, you came up and you started screaming and yelling and you were disrupting the meeting, you freedom of speech, and I have every right to be here, and you're gonna sue us, and you just went on and on. I mean, I can't remember everything you said, but for a good half hour, you were screaming and yelling at everybody and approaching people, and they were telling you to back off or to be quiet, and you wouldn't listen to anybody and just kept screaming on and on and on. So we had to stop the meeting.
What was the reason why I was voicing my objections? What was going on at that meeting?
I don't know, we were having a regular board meeting discussing business, and you just come and just start screaming and yelling, freedom of speech, freedom of speech. And we tell you, you have every right to say what you want to say as a resident, but you can't just come in and disrupt our meeting. We were willing to let you say what you want to say, but not when you just stand there and scream and don't let anybody talk, and people are trying to reason with you and you just didn't want any part of it. So we just had to end it.
Was it at that board meeting where you notified the members that you were suing me?
No, I never said that. I don't disclose any legal matters to any resident. I keep it between the lawyers and myself. That's it. I don't tell any resident anything.
Was the lawsuit not discussed during that meeting?
No. In fact, people want to know why we're not doing anything to you. And I said, this is the reason why, because you just interrupt everything and you don't let us talk.
So mentioning the lawsuit and pending lawsuit never occurred during that meeting?
No, we don't, like I said, we don't discuss particulars. If people know there's a lawsuit, fine. When they ask me questions about it, I refuse to answer any questions.
So in the board meeting minutes, you did not mention that there's a potential lawsuit?
No, because nobody said anything about a lawsuit. We weren't discussing a lawsuit. We were discussing our business that we were trying to get through.
Do you have the board meeting minutes for that meeting?
They're on our website, which is open to everybody.
That was something that was requested for production. Can you please produce them?
Why can't you go on the website and print out a copy yourself?
Yeah, let me try to keep you all from avoiding arguing back and forth. If something is in the domain of all the homeowners, then that's something that is a valid response, Ms. Elkins. I would caution you to try to be specific, if either of you can, about the date that you're referencing. It's quite possible, based on this back and forth, that you're talking about two different meetings. I don't know. So please be specific in those questions.
What was the date that I interrupted, or that you're claiming I interrupted?
I have no idea, ma'am. I have to look and go through the records and find out. I don't know the date. I believe it was in May. Was it May? Maybe sometime in May or June. That's when we had our first meeting, but the specific date, I have to look it up.
Okay. Now, you've locked me out of the clubhouse. Have you not?
Go ahead, answer.
Yes, we did lock you out of the clubhouse because we have 2 employees that work there full time and they were afraid of you. So in order to keep our employees safe, we had to lock you out of the clubhouse, but you have access to every other amenities on the property.
Do I not have a right as a resident to have access to the clubhouse?
Yes, you do. If you don't threaten our employees, yes. I have to worry about the safety of my community and my employees. And if you're going to threaten them, I can't have you come in the courthouse.
So are you going to refund me my money that I'm paying for these services?
No, because there are a lot of services other people don't use and they don't get reimbursed for not using them. So why should I reimburse you?
That would be their choice not to use it.
Well, until you can prove that you're not going to go after my employees and you're going to be respectful, then I'm sorry.
What employees have I gone after?
Well, you intimidate Miss Bill. She's our property manager, and you also had a case against our social director for spitting on her.
And what happened with that one?
I have no idea. I wasn't privy to the outcome of that.
Would it surprise you that I was found not guilty?
You were found not guilty.
I was found not guilty. The case is dismissed.
With no. Okay, well then.
Do you have any more questions, Ms. Elkins?
I do, yes, Your Honor. All right, so Ms. Bonelli, in your motion for temporary injunction, you have identified me as speeding. Do you have any evidence of me speeding?
My eyes. I have no radar gun that, calculated your speed, but I mean, if my eyes and what I hear from other people that witness you speeding down the street.
Okay, and what other people have reported to you that I've been speeding?
Well, half the people on Marbella Drive that have children that play on the sidewalk, they see you speeding by. You can tell somebody doing 20 miles an hour versus somebody doing 50 miles an hour, 40 miles an hour.
Okay.
But
so what would you say is the average speed of someone going down Marbella Drive?
It should be 20 miles an hour. And the majority of the residents do that.
What percentage of residents do that?
I would say maybe at least 3/4 of the community does that.
3/4 of the community overall, or just around Marbella Drive?
I can't speak for the other streets because I don't live on there. I live on Marbella Drive, and I noticed that most of the people on Marbella Drive watch the speed limit.
Okay, and so what would you say that they're going 20? Would you say that they're going 15? Would you say they're going 40? How fast do you think these cars are going?
I would say at least 20, maybe 25, but more than that, I can't. I don't think so.
Someplace between 20 and 25, on average.
That's what I'm saying. Yes.
How fast am I going?
You have to be, in my opinion, you'd have to be going at least 35, 40 miles an hour, if not more.
At what points?
What do you mean?
On a basis, on once, twice?
No, I've a lot of times I see you and I just turn around and walk back into my house because when you see me, you have the urge to come after me. So I try to avoid seeing you, but I do see you go by.
So you see me going by, but you turn your back because you want nothing to do with me.
Correct.
And yet you're reporting the fact that I'm going someplace between 30 and 40 miles an hour?
Yes.
With your back turned towards me.
No, my back is not turned towards you. No, it's not.
You just mentioned the fact that you walk away. When you see me, you turn your back, you walk home. You walk away.
I'm sorry, Mr. Gal?
I objected. She's mischaracterizing Ms. Bonelli's testimony.
Well, I have to confess, I'm not sure that ultimately this is all that helpful to the court in trying to figure out whether there should be a temporary injunction here. So it's kind of devolving into a bit more argument here. Do you have more questions with regard to facts, with regard to anything that Ms. Bonelli may have personally seen or witnessed, etc.? I'm really not interested in opinions, although there is a law that makes clear that civilians can offer their opinion with regard to the speed of a vehicle. But other than that, opinions are not of interest to me. So any other questions, Ms. Elkins?
Ms. Bonelli, why do you think I'm so upset?
I have no idea. I can't judge you. I don't know you. I've never had a conversation with you. I don't know you, so I can't make any kind of evaluation.
When did these problems start?
I believe when we put the speed bumps down.
Mm-hmm.
By the way, there was one speed bump there that was there for years that you never complained about. You just started complaining about the second speed bump.
Okay, and why was I complaining about the speed bumps?
You said you have a 20% back injury and it hurts your back to go over the speed bump.
Did I provide documentation of a disability?
You gave us a note from a physician's assistant that you have a back problem.
From the physician assistant. What date was that, Ms. Bonelli?
I don't remember. I don't have the information on me.
Was that roughly January, February, March, April, May, June?
I told you I don't know.
Ms. Elkins, I'm going to ask you, this is not television quality legal drama here, okay? I know that this is emotionally charged for both sides. I respect the emotions on both sides, but I'm going to ask both of you to take the tone of your voice, remove the sharp edges from it. Just ask the question. This is not the greatest legal drama, okay? I know that you are engrossed in it, but just ask the questions without the top spin, please.
Yes, Your Honor. All right, so January, you install a speed bump. Is that correct?
Like I said, I don't have that information in front of me, but if you do, then...
Give or take January, you install a speed bump.
Excuse me?
Give or take in January, roughly around January, you install a speed bump.
Okay.
Okay. Are you aware that that is a violation of the county? That they sent you a violation notice on September 16th, letting you know that the speed bumps were illegal?
Yes, they did tell us that, but before that, previously, we were told by the county that since this is a private community and our roads are private and the speed bumps weren't installed permanently, then there was no issue.
All right, now, Ms. Bonelli, is that the same speed bumps that were also installed in the condos?
No, they're different.
They were different.
They were much more, how can you say, aggressive? They were
Taller?
They were steeper. You know, they weren't as, we had, the ones that we bought were more like a speed cable, which was just like a little pump that we installed, but the condos installed something more severe, I would say. It's more of a dip.
Well, that's interesting because I'm looking at the Marbella Lakes Condominium Association Board of Directors regular meeting dated Thursday, January 30, 2020. And that is something that I had previously sent to you. In that, there are meeting minutes that talk about, there was dialogue and comments that the speed bumps that were put in place were illegal, as well as dialogue that they were not illegal in the private development. Also dialogue on whether an engineer study by Collier County is necessary or whether an engineering study is a waste of time. They ended up removing the speed bumps because they were illegal, did they not?
Yes, they removed them, but not because they were illegal, because too many residents were complaining about them.
Okay. And what was the feedback regarding the speed bumps on Marbella Drive?
Actually,
were people complaining about that as well?
They were very favorable feedbacks. People were very happy that we put them there. And when we took them away, we got some residents that approached us and said, why did you take them away? We were happy with them. So you have a mix.
So if you look at the board meeting minutes, that evidence will be supported? Your testimony would be supported by what's in the minutes?
No, because we didn't have a board meeting about speed bumps. This was just people coming over to us, telling us that they were happy that we put them there for safety reasons.
Mm-hmm.
Let me interrupt again and try to redirect. This isn't the trial on the main issue. What I'm asked to decide today is whether there are behavioral issues going on from Ms. Elkins that would support this court entering a temporary order restricting some of those behaviors. So really what you're aiming at here, Ms. Elkins, I think is anything that undermines their allegations that you're committing these behaviors. Telling me that you're justified in these behaviors because what they did is wrong won't ultimately be helpful here. I need to know whether there are unsafe behaviors going on that I need to step in or not. And I need to clarify, because there was a statement made a moment ago, which you have to appreciate, judges have information. A criminal case was brought and it was dismissed. Well, it was a successful completion of a diversionary program. It was not dismissed. That was misleading to the court. I don't know that you meant to do it, but I looked it up. There was a misdemeanor case brought. It was diverted, and you did successfully complete diversion, and that case was subsequently dropped by the state attorney. There is now a pending felony case for an aggravated assault with a vehicle. Looks like you had a first appearance and were released on a $10,000 bond about a week ago on that. I do also have 2 citations for driving off of the road. One, you elected driving school, and the other adjudicated guilty. So you've opened the door to me looking at your driving and criminal history. That is an accurate statement. It's all public. I've not shared anything private. But that is, again, I'm being asked to determine, do I have a threat to public safety here? I looked at that, Ms. Elkins, because you told me with a little topspin again, your case was dismissed. So I want to make sure that we're all clear on what's going on there. And I don't show counsel for your pending felony case, and it is appropriate that I let you know that you have the right to remain silent on that. And so if you do make statements that are incriminating with regard to that case, I don't have a prosecutor. I am not a prosecutor, but you have to understand you've got people on the other side here who are not on your side. So I want to make sure that you're aware of the fact that you do have an open criminal case that appears to go to the issues of what I believe we're going to be discussing here today. I need to stick to those issues, and if there's a question that comes up that you do not wish to speak on, Ms. Elkins, I'll remind you it's your right not to do so. All right, do you have more questions for Ms. Bonelli?
I do, Your Honor.
All right, Mr. Gal, call your next witness, please.
Your Honor, I said I do.
Oh, you do? I'm sorry, I heard I don't. Go ahead.
So, Ms. Bonelli, you mentioned that you have over 100 complaints about me.
Yes.
Who reported that I was driving on driveways?
Oh, I don't know all of them, but there were. I don't. I think you're saying the wrong thing. It's not driveway. You're on the sidewalk. You're driving past people at a high rate of speed. You're blowing their horn at them. You rolled down your window and started cursing at an old elderly couple who was walking by, just minding their own business.
Ms. Bonelli, have I ever been threatened here?
Excuse me?
Have I ever been threatened here?
Not to my knowledge. You're the one that's threatening everybody.
No one's ever come to my door. No one's ever come into my property.
I'm not aware of that. I don't know. I'm not sure.
Have I sent out emails asking for protection?
I believe I remember one email saying that you fear for your life.
Mm-hmm. And why would I say that I would fear for my life?
I don't know what goes on in your mind. I have no idea.
Did you bother to ask me what my concern was?
No.
Because saying that I fear for my life is pretty intense words. Would you agree?
Yeah, I would. but so can a few other people in our community say they fear for their life because of you. So, I mean,
How many times did I request a meeting to discuss what was going on?
I don't recall.
Do you recall me ever sending out an email either to you, an association member, an association's attorney, requesting a meeting to figure out how to resolve this issue?
I believe so, but I think we were advised not to until we were deposed or had a mediation, which you kept canceling.
When do you think to your knowledge, when was my first email sent out requesting a conversation?
Honestly, I don't know. I have to look through all the emails to find out.
Take a guess. What month do you think I first requested
I
this?
don't know, Victoria. I can't give you an answer that I don't know.
Would it surprise you January?
If you say so, if you have it in front of you and you said it's January, then fine. I mean, I can't say to the fact that it was January because I don't have that information in front of me.
What was your response? Let's say that I did send it out in January. What was the association's response?
Not to engage as per our legal counsel.
Why was legal counsel brought in back in January?
No. Because you were just terrorizing the neighborhood. I just can't think of another word to use, but people were just frustrated that you're allowed to do what you're doing and everybody's afraid. And why is it that, they can't live a normal, peaceful life?
So what was I doing in January?
I don't recall. You've done so many things I can't keep track.
You're saying that people were terrified, which is why you didn't engage with me.
Because I fear for my life too, the way you threaten me and my husband. And I can't sit outside in front of my own house without you coming up to my driveway and start screaming and yelling at me. And
when did that happen?
Numerous times.
Before or after January?
Before and after.
Before January.
Yeah, that's what I said.
When in January?
Oh,
Objection, argumentative.
Sustained. That's not going to be probative of anything.
So knowing that my behavior was escalating, did I ever mention the fact that my disability is causing problems?
Yeah, but you keep mentioning it's a 20% disability of your back. What does that have to do with your mental capacity? I don't know.
Did I mention any other disability?
No, just your back.
Did I request accommodations for my disability?
Yes.
And what happened to those accommodations?
Nothing.
Why were they refused? Were they accepted?
Again, we were told not to respond.
Okay, so they were refused.
Yeah, not refused. We just didn't entertain them. That's all.
So, are you aware of Fair Housing Act?
Yes, I am.
What's your understanding of Fair Housing Act?
Objection, relevant.
Yes, sustained. That's way too big a question. Be a little more specific as to what your concern is.
With the Fair Housing Act, if someone is disabled and requests reasonable accommodations, are they permitted to be refused?
If they're
Or
reasonable.
ignored?
Objection calls for a legal conclusion.
Sustained.
You're seeing that I'm requesting accommodations. You're seeing that I'm requesting a meeting to discuss how to get me home without being in pain. Yet you refuse it. You ignore it. If you met with me If you provided reasonable accommodations, well, first of all, had you even gone to the county and got the speed bumps installed legally, we wouldn't be in the situation because they couldn't have been installed. So my response was in relation to what? The speed bumps being put in illegally. Speed bumps escalated my disability, you know?
Ms. Elkins, let me clarify, make sure I'm following this. There was a speed bump put in, may or may not have been done correctly, but it has since been removed. Do I have that right?
The county has since come back and told them that they need it.
So if that speed bump is gone, then from a legal standpoint, in terms of my obligation to evaluate the merits of this motion, it's moot. It may have been in place, it may have irritated you months ago, it's since been removed. The question that I'm being asked is whether in today's circumstances, there needs to be a court order restricting some of your behavior or not. So I'd like to focus, I understand there's a lot of history and you'd like me to know all of it. That's not going to happen. I need to know whether behaviors are going on right now that threaten peace and safety or not. So rehashing a speed bump that has since been removed is not really going to advance the cause for anyone here today.
All right, Ms. Bonelli, you have reported that people have complained about me honking the horn, is that correct?
Yes.
What's your understanding of why I'm honking my horn?
Better answered by you, Ms. Elkins. You can tell me why you're honking the horn. For her to guess why you might be honking the horn just doesn't help the judge evaluate the legality of the situation. So you've asked her now several times. Mr. Gallo's been patient, but asking her to suspect why you might be taking certain actions is actually not a proper question. But you will have the full opportunity to tell me precisely why you are taking certain actions. So take some comfort in that.
Ms. Bonelli, has the association identified a safety concern with pedestrian animals on the sidewalk and thus denied removing the speed bumps?
Objection made. Comment.
Has the association sent me an email identifying on dated September 14th, 2020, identifying safety concerns and stating your request to remove speed bumps was not an option in light of the safety issues caused to people and pets in the community?
I don't remember.
I think that's a reference to the email from Mr. Samoose. And the
Yes.
speed bump has since been removed, right?
Speed bumps have since been removed, correct, Your Honor.
Okay.
The reason I'm honking my horn is because the association has identified a safety concern.
Okay. We'll get into that in a minute when you testify. I haven't put you under oath yet, but we'll get into that. Do you have any other questions for Ms. Bonelli as to what she has witnessed or what her perception is?
Yes, Your Honor. Ms. Bonelli, you are claiming, or the association is claiming, you are the president of the association, that I assaulted and battered someone by the speed bumps. Is that correct?
Yes.
Okay. Who did I assault and batter?
Well, first off,
Speed bumps?
like you said, we've been cleared of it or whatever, it's been dismissed, but our social director.
Mm-hmm. And that happened down at the speed bumps?
Excuse me?
And that happened down at the speed bumps?
No, that happened on the pickleball court when you were disrupting the pickleball game because you were telling the people that they shouldn't be there because that's your area where you do your exercise.
So specifically speaking, as it relates to the speed bump, who did I allegedly assault and batter?
Our previous vice president, Pam Jacobs.
All right, so I sent you Exhibit 3. Can you please pull out Exhibit 3?
Is that something the court has, Ms. Elkins?
I know it was submitted through the e-file portal.
Okay. When did you do that?
Before the last motion.
Okay.
I'm sorry, Aaron, I don't know the date offhand that I sent it, but it was supposed to be.
Was that a 32-page submission? I have a document that was 32 pages.
I imagine it's probably in the possibly 32 pages. It's the only thing I submitted for the last motion.
Okay. And so within those 32 pages, can you direct me?
I know it's titled Exhibit 3.
Okay. That's a sheriff's office report?
Yes, it is.
Okay.
Ms. Spinelli, is this the incident that you were referring to?
Yes.
Okay. If you go to where, so the incident, what happened?
From what I heard and from what I read, you were trying to avoid going over the speed bump and you couldn't. You were going up on the sidewalk, but there was a steel, rods to prevent people from doing that. And you got out of your car and you went to pull it out of the ground. And Pam went over to you to put her hand on yours to tell you to stop doing that. And you stood up and you took both your hands on her shoulders and pushed her. And she went back, but luckily she didn't fall.
All right.
Police were called and they filed this report.
And the police reviewed the video, is that correct?
I don't know, I guess so.
Okay. So, who was the aggressor in that incident?
Well, according to the officer, it was Pam,
Mm-hmm.
but then you pushed her, so it was both of you actually.
So, would you say that I used self-defense when I was being grabbed?
Objection calls for a legal conclusion.
Sustained.
With the two officers reviewing the video and claiming that I used defense, that I was actually the victim.
Objection hearsay.
Sustained.
In the video, you can see the victim lunge towards Elkins and grabbing her. Elkins then pushes the victim away. What would you have done if someone grabbed you?
Objection relevance.
Oh, and speculation. Yeah, sustained. Those are not proper questions.
So you're claiming that I assaulted and battered Pamela when I pushed her off me. Yet the police have found no cause to pursue that. In fact, according to the email sent on January 7th, on January 8th, sent from Pam Jacobs, she identifies and says, the officer did not think I would have probable cause to issue an arrest warrant because when she got out of the car and drove onto the lawn and sidewalk, she got out of the car, opened, and started to pull out another stake on the ground. At that point, I did take her hands off the stake and was shoved. So in hindsight, from what the officer said, I should have allowed her to once again continue damaging our property.
Objection, Ms. Elkins is testifying.
I'm not actually sure what that was, Ms. Elkins. Are you reading from a document?
I'm reading from, yes, Your Honor, I'm reading from Exhibit 5.
Okay. Let me be clear. You can file these things in the court file and I can pull them up potentially, but unless or until they're admitted into evidence, the contents of those documents are not admissible and you can't be reading them. I've been kind of waiting to see where this is going, but if you're going to use these documents as evidence to try to prove the truth of what's asserted in those documents, that won't be something that you can do. Do you have Ms. Jacobs or the officer as a witness today that you want to call them to testify on this?
I would like them to be able to testify. I would like Pam to testify. I would like anyone who's come back and filed a complaint against me to testify.
Have you subpoenaed them?
I have not.
Okay. All right. Well, generally speaking, people's statements made outside of court can't be used in court. That's hearsay. So I kind of let it go for a little bit, but if your intention is to go through several pages of documents from an event and just read what people wrote, that won't be evidence that I can really hang my hat on. Now, when you testify, you can tell me about what happened because you were there. You can tell me your standpoint. But to tell me what Ms. Jacobs said out of court or what the officer said out of court is not proper.
Okay.
Do you have other questions for Ms. Bonelli?
What was the reason that the speed bumps were not removed?
I'm sorry, I didn't hear you.
What were the reasons that the speed bumps were not removed?
I thought they were.
County getting involved?
They were removed. They were removed
What's the reason that they were not removed prior to the county getting involved?
because we were under the impression that they were legal. We were, like I stated before, we were told that it's a private community with private roads, and as long as they weren't stationary, they weren't permanent, then, and they were removable, we were allowed to put them in. That's what we were told by the county. Okay, so the code enforcement, if they have different laws and rules, that's when we found out, because you called the code enforcement and reported us.
Who in the county told you this?
It was 3-4 years ago, and it was, I don't remember.
3 or 4 years ago, you called the county about installing the speed bumps.
We had one speed bump that's been there for a long time that you never complained about. You started complaining about the speed bumps when we put the second one in closer to where the children play. That was your issue, that speed bump, not the one that was there for years.
Did you ever talk to Michael Sweeney?
Who?
Did you ever talk to the neighborhood traffic management program?
I wasn't involved with that, no.
You were not involved with that?
No. We have committees that we're doing traffic and looking into different areas where we can provide safety.
So the reason why your attorney has, or you have identified yourself as speaking to the neighborhood traffic management program?
We have a committee in the community that's into safety issues. Speed bumps were one of them. Stop signs, which we just installed because we had to take the speed bumps out. No.
So did you ever talk to the county neighborhood traffic management program?
I never did personally, no.
Did any board members speak to the neighborhood traffic management program?
I can't answer that. No.
I'm sorry, what was you gonna say?
I said I can't answer that. I don't know.
Would it surprise you that you answer the interrogatories? As the president, are you involved with the interrogatory answers?
Yes.
You are?
Me and the lawyer? Yes.
What was your answer to that interrogatory question about whoever spoke to the neighborhood traffic management program?
Actually, I don't have it. I don't know. I don't have it in front of me. What does it say that I said?
That you were involved with that.
The only involvement I would know would be at a board meeting to approve them. That's it. But I didn't speak to anybody in the county. Maybe another board member did, but like I said, I didn't speak to them personally.
Your Honor, may I have a 5-minute recess to find that information?
I'm not sure that that's really likely to get anything useful here. Again, I'm concerned with allegations of behavior, whether they did or did not happen, whether there's a safety issue, I need to step in. So I understand where you're going. She may have said she did it. Today she's saying she didn't have any involvement in it. That's not a terribly salient point. So no, the motion for a recess is denied. We need to keep moving on this.
Well, my concern, Your Honor, is she's testifying to one thing, and yet she's also saying the fact that she's done something else. She's saying that she was never involved with the neighborhood traffic management program, and yet their answers to their interrogatories is that she was.
I get it. I accept your proffer on that. Why don't you ask your next question?
You mentioned a letter that I sent the association regarding my disability.
I mentioned it.
Did you not receive a letter requesting accommodation?
It's the letter from a physician's assistant telling us that you had a disability and you can't go over the speed bumps.
Mm-hmm. That it was escalating my disability and making it worse.
If you say so.
Objection has been answered.
Yeah, what's the question, Ms. Elkins?
I'm just wondering if safety is taken so seriously. Why not intervene? Why continue to ignore the situation? Why choose to ignore me?
You complained about the speed bumps and they were taken away. What more do you want us to do?
When did I start complaining? Back in January?
Well, you complained, but you know what? For the safety of the community, we left them there until you called the county, and then we had to take them out.
Who's responsible for knowing the laws?
Objection.
This is not, yeah, it's not helpful. I'm still, here's what I'm going to beg you to try to help me understand, Ms. Elkins. You seem to have had a valid dispute with a new speed bump, and you seem to have successfully fought to get it removed. And that seems to have happened some time ago. What I don't understand is why there's so much animosity and conflict right now that I'm actually being asked to enter a restraining order against you. So, we keep litigating. It's like not helpful. The speed bump's gone. You were victorious, I think, is one way to look at that. But why there's still conflict that's the part I'm not sure I'm understanding. Why didn't everybody go home happily once the speed bump was pulled out?
I don't know. You asked them why they continued with the lawsuit.
Well, that may be a different question. But again, I'm being told that there's behavioral issues and confrontations and threats to safety. I'm not yet persuaded that there are any of those things, but that's what I need to get to the heart of today. So to continue to gnash on this speed bump that you wanted out, that has been removed, I don't know how that advances anyone's cause here today. The speed bump's gone. What's going on now? Why is there a problem now?
Well, let's talk about the horn usage.
Okay.
Do
you have a question for the witness?
What was the safety concern to pedestrian animals that required the speed bumps to not be able to get removed?
It was to slow people who were speeding in the community, to slow them down.
So again, I understand that was the purpose of the speed bumps, but what was the danger that was so grave that the speed bumps could not be removed, that you couldn't do what you're doing now and install the stop signs? The speed bumps could not be removed because it posed such a danger to pedestrians and animals. What was that danger? Help me understand that so I can stop using my words, whether or not this
Stop. This does not merit that level of drama and animosity. It does not. I just want you to ask the question. I just want to get the answer. We're going to do our best to get through.
What I've been seeking all along is an answer to what's the danger, because I don't want to hurt anyone. So I am using my horn to notify people that I'm coming, especially when it's dark outside, so I don't pose a danger to pedestrians and animals which the association has already identified was the reason why the speed bumps could not be removed. So again, what is this danger? So I can, if the danger exists, I'm trying to save you guys. I'm trying to protect you from danger. If it doesn't exist, then why did you state that this danger existed?
Well, first of all, with your horn blowing, how could you, I mean, you're blowing your horn, and I have it in writing from a resident, a couple of residents, that you have to blow your horn at 7 o'clock in the morning on a Sunday morning and wake everybody up. I mean, you blow your horn as you're driving. I was witness to the day that you approached me and my husband. You drove down Monterey Point with your hand on the horn. You turned on to Laguna with your hand on the horn. You turned on to our street with your hand on the horn. There was nobody on the street. Who are you telling that you're coming, or you're trying to make them safe? There's nobody on the street. So why are you blowing your horn at the ridiculous hours of the day and night?
How do you know that my hand was on the horn?
Because I heard you, Victoria. I was a witness to it. I saw you.
That I was honking the horn, or that my hand?
No, you had your hand on the horn. That's the day you assaulted me with my husband. I was a witness to that. I saw it and I heard it, okay?
I assaulted you. How did I assault you?
You prevented my husband from walking back to our house to go into the house. You would not let him pass, and I had to try and move his walker around you to get past you, and you refused to move.
So how was I preventing him from walking?
You stood right in the middle of the walkway. How was I supposed to walk around him?
I stood
around
there.
You.
I stood there. What was my body doing besides being firmly planted there?
You were standing there with your cell phone in my face, harassing me and my husband.
Uh-huh.
And you gave the officer a copy of that. So if you want to, if the judge would like to look for it, it's in record with the court.
So I stood there.
Yes, you stood there.
And that's assault.
Oh no.
Objection argumentative.
Not sure we're getting anywhere here, Ms. Elkins.
All right, so again, what is the danger to pedestrians and animals that the speed bumps could not be removed? And how is that danger now eliminated with the speed bumps removed?
Because now we investigated further and we installed stop signs to stop people from speeding down the street. We had to remove the speed bumps, so we had to come up with a different solution. And that was the solution that the committee researched and looked into and went to the county and found out everything that we were supposed to do, and we did it. So now we're trying with the stop signs.
So now the danger's been eliminated?
No, I'm saying it's been eliminated because if you don't stop for the stop sign, the problem is still there.
So danger still is present?
It could be, yes. If people don't abide to the stop signs, yes.
So stopping in one place, what eliminates the threat?
Yeah,
what about the rest of the development that doesn't have the stop signs? Is the danger present there?
They all have stop signs now.
There's areas, so the the stop signs are covered with the association. There's no areas where there's no stop sign.
We installed six additional stop signs within the community.
And how long is the development? How many miles?
I don't know, 4 miles.
Okay, so within a 4 mile period, there's 6 stop signs, or 6 new.
There were more stop signs before that. These are just the 6 that we added in addition to what was already in the community.
So are there areas of the development that do not have stop signs?
I don't believe so. I think now with the 6 stop signs we put in, now they all have stop signs.
So there's no areas of the development that don't have stop signs?
I don't believe so, no.
What's the distance between the 2 stop signs?
Oh, I don't know. Victoria. I'm not a professional. I don't know.
So let me just jump in.
I'm just trying to understand how the danger's been eliminated.
Here's the difficulty.
Stretches of development that don't have stop signs.
Ms. Elkins, what they're suggesting is that you have become so thoroughly unable to get along with everyone there, and your coming and going has become combative and disruptive and so forth. you're not helping your cause here in trying to demonstrate to me that, Judge, I can handle my behavior. I'm not combative. I'm not going to disrupt the peace in this neighborhood. Do you see how this hearing is really sort of an audition as to whether I need to do a court order to restrict behavior or not? Every time you kind of get ahead of yourself with the behavior, it really lends credibility to what they're saying, which is she's disruptive. She won't let people get a word in edgewise. Your arguments and your questions suggest that you're engaging in the behaviors they're accusing you of engaging in. I need to stick on those issues. If you're not engaging in those behaviors, if you're not bothering folks, if you're not blowing your horn, if you're not driving off the road, if you're not doing those things, that's what I'm here to understand. But to get combative with Ms. Bonelli kind of reinforces their point. So try not to do that.
When was the last time that I drove off the road?
I don't know, Victoria. I don't follow you around all day long. I don't know.
When was the last time someone, I mean, you mentioned that there's over 100 complaints. When was the last time anyone reported that I drove off the road?
I believe it was the day after we had our first appearance before the judge that you stopped.
That I stopped. Did I stop before or after the speed bumps were removed?
After.
After.
Mm-hmm.
So I drove on.
Removed in October. You stopped. We had a court date in December, and you stopped the day after the court date.
So who reported that I drove on the grass?
Numerous residents. They walk, they see you. They're walking and they see you driving up on the grass and around the speed bump and back on the sidewalk.
But now the speed bumps have been removed. I'm still driving on the grass. So
I didn't say that.
I'm sorry?
I didn't say that. You were driving on the grass before we removed the speed bumps.
Yes, before the speed bumps were removed, I was driving on the grass. After the speed bumps were removed,
you had no reason to go on the grass because the roads were clear. There was no speed bumps for you to go over to injure your 20% disability.
okay, so then I stopped driving on the grass, to your knowledge?
Yes. As far as I know, yes.
When did I start using my horn? Before or after?
I would say right after we removed the speed bumps. Because according to one of your emails, I believe, you said that you were doing that to warn the people that you were coming.
Mm-hmm. So that's where I'm confused. If the danger was present.
I follow your argument, Ms. Elkins. I'm right there with you. I understand. We've kicked this horse 20 times, but I understand.
Let's simplify things. If the danger is not present and there's